what I was saying is that when the party, either one of the parties, whether the claimant or the respondent, they are at liberty to write to the institute requesting for appointment of an arbitrator. Now, what happens when we get that letter? We have to ascertain that, number one, we are truly the appointing authority. And this is usually through looking through the contract documents, where we look at the arbitration clause itself, and we see how it is worded. There's some contracts, and this is something that the vice chair will look at, where the arbitration clause, on most of them in this case, provide that parties may have tried to appoint themselves, or maybe their pre-qualifications to it, they request that the parties try to amicably settle the disputes, or if it's a multi-tiered contract, it provides for negotiation, mediation, then maybe conciliation, then arbitration. We look at whether all these pre-qualifications have been met. So we request for these documents to ascertain that, number one, we are truly the appointing authority, because we cannot be able to proceed if we are not truly the appointing authority. Should the contract be silent on the appointing authority, and in most cases we find this coming into the institute, where it is indicated should a dispute arise, then this matter goes into arbitration, and then it's silent. So what we encourage parties to do is either they have a consent where they agree to vest the mandate of the appointing authority to the institute. Should they not then be able to agree on that, then they can make the application to the court, to the High Court, and then the High Court can then give that mandate to the chairman of the institute. So the first point is at the point of making the request, or at the point of request for application for appointment of an arbitrator, we request now for the complete contract agreement, so that we look at that. So that we are also ascertaining that the parties have truly met, or they have gone through the provisions of the arbitration clause. We'll request for all relevant written correspondences, specifically relating to the provision of the dispute resolution clause. So it is at this point, from these correspondences, that we're able to ascertain that truly, at least the parties were able to try to mutually agree or come to an agreement and failed. They tried mediation, if it is a provision that is included in the arbitration clause. They tried, making the appointment themselves, because you'll find that there are also clauses that say that the parties will try to appoint an arbitrator, and it's at the failure of which then they come to us. So these correspondences ensure that we get to understand and to verify that that has truly been achieved. Then we also request for a summary of the nature of the dispute. This gives us an insight as to the nature of the dispute, so that we are able to understand then how to, through the vetting process, we're able then to understand which arbitrator would be ideal for the nature of the disputes. We also look at the details of the damages or the quantum of the disputes. This allows us also to get some sight into how complex is the dispute. Because you'll find through the statistics, you will note that we receive as low as 120,000, because that was the statistics of last year, where the lowest quantum was 120,000 to billions and billions of shillings. So through getting the details as to the damages or at the quantum of the disputes, then we can be able to assess if it's a very complex case, because you'll find that the higher the quantum, the higher probability it is a complex case that may require a senior member or a senior arbitrator to handle. Then details of the parties to the dispute, so that we know even in our correspondences who it is that we're writing to, as well as now confirmation of the appointing authority as the chairman. In the event that none of these documents are yet to be made available, unfortunately, we are not able to progress, because we do not want to get into a situation whereby we progress with the appointing or with the appointment, and then later on get to learn that there are some provisions that had not been met with, which then complicates the process. So once we get and verify the documents, and we find that those documents have satisfied the requirements, a letter of acceptance is given, and we request now for the appointment fee. Currently, under the recommended guidelines of the charges of the Institute, the appointment fee is 20,000 for request for an arbitrator. We also have instances where the parties essentially are the ones charged with making the appointment, in which case they can also write to us requesting, can you give us maybe 2, 3, 4, 5 names of arbitrators within this particular field, or with the qualifications that they request, and then we can give that. Every recommended name of arbitrator is 1,000 shillings. If it is appointment for a mediator or a construction adjudicator, it is 10,000. So once the payment has been done, we ensure that we ensure that by the time we are requesting for payment, all the pre-qualifications have been met, all the documents, the contract, the correspondences, all have been shared with the Institute. There are instances where they are all brought together, including the check. So then that we have to do the due diligence and request for this documentation. We do not acknowledge the payment until we have sufficient documents submitted for considerations. So if the parties have fully exhausted the initial process that we had indicated, then we confirm that the matter is now ripe to proceed to appointment by the chair. So it is at the Secretariat that we do all this in terms of ensuring that the pre-qualifications, that they've complied with everything they've indicated in the dispute resolution clause, so that then that matter is written to the chairman for nominations. So what we have done, and to ease the process, the chairman has alluded to it, is that we have introduced a form that will make it easier for applying parties to capture all this information and to ensure that they are compliant, because we've realized that there are instances where a lot of time passes between when the application is made and when the parties comply with all the pre-qualifications that we've talked about. So the request for appointment of the arbitrator form essentially should address some, if not all, the issues that we have outlined. It articulates who the parties are and their contact details. We have the claimants, we have the respondents. Then we also have here the nature of disputes. So it also assists us in knowing if the dispute is within the, if it's a construction dispute, it's an insurance dispute, it's a sale of goods. So it becomes easier then to know if it's a construction dispute, then you're likely to appoint someone within the construction or the built environment. We also look at the amount in dispute. When we talk about damages and the quantum, then it is indicated there. The form will also request that you put in here the excerpt of the dispute resolution clause, so that by looking at it, you are able to know from the onset that whether the parties have complied or haven't complied with the provisions of the dispute resolution clause. Then we are looking at, have the parties attempted and failed to appoint an arbitrator? So should the arbitration clause have a provision that the parties should try to appoint before they come to the Institute? Then they can choose. If yes, then they provide the names. This is to ensure that the Institute then doesn't get into a position whereby, without its knowledge, and you'll get to appreciate that, and especially for those who've handled disputes, some of these arbitrations, you get hundreds and hundreds, sometimes even to 1,000 of documentation. So before you sift through all this documentation to see whether there was an appointment made or the parties tried to appoint a particular person and couldn't agree, so we get to know that this person was had tried to be appointed and maybe did not. It did not succeed. Then now the summary of the dispute, so that we get some sort of clarity as to what the dispute is all about. In most cases, in very rare cases, as we've seen, the instances where the arbitration clause indicates the preference of the arbitrator's background. So you likely find clauses stating that the arbitrator to be appointed should be an engineer of 15 years experience, or should be an advocate of 10 years post-admission experience. So this is where we get to capture that information. It also assists the vetting committee to know that the person that we are going to appoint also complies with the provisions of this. We've put a disclaimer here because number one, the preference of the arbitrator is something that is anchored within the arbitration clause or the parties have agreed to. We've received instances whereby one party purports or makes requests without the consent of the other party as to the qualification of the arbitrator. So to avoid that instance, so we've requested that there, first of all, it should be a part of the contract or it should be part of the dispute resolution clause. If not, then the consensus that should be supported in writing then can be made available. So this is the part where you make the payment, and then there are some preconditions as to that, and then the signatures of the party making the application. There's also aspects of the payment and how to go about it, and also a checklist. So the documentation that we've talked about should then accompany this form. So the form should not be considered as the one-stop all. It still needs to be supported by the relevant supporting documentation. So having said that, we'll make that form available to you. We've concluded the administrative bit here at the Secretariat, and we've now confirmed to the parties that the matter has now been forwarded to the chairman to make the appointment. You'll appreciate that depending on the amount of disputes appointment requests that we get, it is a lot of work and human is to err. So the board several years back approved that there be a vetting committee process, or at least what I'm calling the NAS committee, which is composed of the chairman, the vice chairman, and one member of the board, who then form this committee, and they sit and vet through the documentation and ascertain who's going to be appointed. So once the parties have satisfied the requirements, they've made the payment, the institute has then, or now through the office of the CEO, have forwarded the matter to the chairman and the vetting committee to consider and make the appointment. The committee then sits down and they look at everything that we have. Number one, they will look at the compliance of the documentation again to ensure quality assurance. And secondly, they will now, through some internal policies, try and match the arbitration, the disputes with the right arbitrator. Now, I had made reference to the appointments, I'd made reference to the role of neutrals. Within the institute, we have close to 260 members who are in the role of neutrals. And these consist of chartered arbitrators, fellows, and members. Unfortunately, due to the limitation of the skills of associates, they are not necessarily part of the role of neutrals panel. That is to mean that if you're an associate, you cannot be appointed. So for those of you who are still associates 5 years down the line, ensure that you progress to the next membership cadre so that at least you start getting some of this work. So they will look at several factors when making the appointment. Number one, and I've made reference to it, is the quantum. Number two, they will look at from where or from which sector does this dispute come from or emanates from. Number three, they will look at, is it complex? So in looking at those, then they're able to assess and see which arbitrator, first of all, possesses the skills and the expertise to handle this matter. When you talk about quantum, to ensure that there is congruency or there is some sort of harmony in terms of the arbitrator and the quantum, it is not likely that you'll get a 2 million disputes being given to a fellow or a chartered arbitrator. Why? As you're aware, we have the recommended remuneration schedule, which we give as a guideline as to how much an arbitrator should charge. And you'll realize that the amount may range all the way from 10,000 to 30,000, for instance, per hour. And of course, we have the ad valorem rates indicated there. You'll realize if you give a senior arbitrator a small matter, it becomes very expensive for the parties. So the vetting committee then needs to make such consideration to ensure that if it is a small matter, there's a particular threshold within which we consider, then this matter can be given to a member. There's a matter that can then go to fellow. There's a matter that can go to chartered arbitrator. However, we've also realized that sometimes it's not always cast in stone, and you'll find that either due to the specifics of the arbitration clause, you may find a fellow or a chartered arbitrator being appointed in a small matter. Why? Because, for example, the disputes or the quantum in dispute is about 5 million, for example. But then the arbitration clause has gone ahead and stipulated the kind of arbitrator to be appointed in that dispute, in which case they've specified that it is going to be an arbitrator of 20 years experience. And when we look at through our vetting directory or through our panel of neutrals, the only arbitrators with 20 years post-admission experience are fellows. So you may find that sometimes, in as much as we have these provisions or as much as we have these policies to guide, they may not always be set in stone. And sometimes now those are some of the discretionary aspects that the committee has to consider in making appointments. We talked about the sector from which the disputes emanate. As you're aware, dispute resolution is a multifaceted career, or it's a multifaceted profession. When we have dispute resolvers emanating from literally across all sectors. So even within our panels, we have engineers, we have architects, we have lawyers, we have people in business, we have people in literally across all professions rather. So we ensure that as much as possible, we match the dispute with an ideal professional within that specific area. So if it is a commercial dispute, there's a likelihood that the person to be appointed is going to be a lawyer, for example. If it is an insurance dispute, we are likely to locate an insurance professional within that dispute. If it is an engineering dispute, the same thing. If it's a construction dispute, a QS, an architect, and so on and so forth. So that is an additional aspect that the vetting committee usually look at when making the appointment. The third aspect is that to ensure fairness within the appointment, we do this on a rotational basis. So it is not likely that you will get an arbitrator appointed twice or thrice when someone else has not been appointed only once. So what happens is that within our list of neutrals, you will find that if, for example, we have number 1 to 270, for example, if we get a matter of a particular threshold, we're likely, and it meets all these other ones, we are likely to appoint you in this. But should another one arise aligning with those facets as the second one, we're likely to get someone similar to you within the list. So it's not likely that you're going to get 5 or 4 when someone else has yet to get. However, and you will see this from the report, you'll realize and get to appreciate that either due to the dynamics or due to the quantum of the applications coming to the institute, there's a particular membership level that do not get as many matters as compared to others. So for the chartered arbitrators, they're not likely to get as many matters compared to the members, because then those are some of the dynamics that then we have to look at and that inform those statistics. So once they have met all these conditions, then the vetting committee then give a nomination. They propose someone. The person then who's proposed, they write back to the secretariat and say, of all these matters, these are the people that we have proposed. So at the secretariat here, we then write to the individuals asking them that here is a dispute that has come to us. These are some of the pre-qualification. Assess, first of all, whether you're conflicted. Conflict of interest check, that is very, very important. Number 2, do you have the competencies required to handle this kind of disputes? Number 3, do you have sufficient professional indemnity? Number 4, are you willing to take a mentee in your matter, amongst others? So if the person who has been nominated meets all these qualifications and they feel that they do meet the threshold, then they write to us accepting. And it is at that particular point that after acceptance, the chairman writes back to them appointing the arbitrator in this matter to then take over the arbitration. So at that particular point, after which now we have made appointment, the institute become functors official, and I know the VC is going to talk more about that. So that in essence is the nutshell of how the administrative behind the scene of how our dispute appointment services are. I will highlight as to the number of people that we have on the panel, because that is very critical. We have, I mentioned, about 270 something people in the panel. We will then have that conversation as to how do you get onto the panel. But right now, I'd like to invite the VC, or unless maybe there are any questions on the group, please feel free to share that as to the process. But right now, I'd like to invite the VC to give us a highlight as to what kind of statistics have we experienced in the past year, and looking at the trend, how are we doing in terms of disputes appointment services? VC, over to you. Thank you.
Thank you, CEO, for that elaborate covering of that part. Good afternoon, members, and karibuni sana to this session. You may ask, why are we doing this? And I know the chair had highlighted. It is in the spirit of one, transparency, accountability, and improving on efficiency. And what does those three things help us as a CIarb? It builds confidence in the appointing authority, that when you're sitting down as lawyers in your offices, that you can be confident enough to draft an arbitration clause and be able to appoint CIarb. Why? Because you have trust in us. So that is why we saw it befitting that at these early days of the year, we do share with you the process of appointment, so that you can be satisfied and you know that it is transparent, it is accountable, and very, very efficient. The other thing that I would like also to highlight is that these appointments, as the CEO has said, there's a chance that you may just get one in a year. And why is that? Because it is a wheel. It is for the Rotarians in the house. The rotary wheel has clogs. So this one has very, very many clogs. So we move from one clog to the other. So you must wait until your turn comes so that you can be reached. So it can take a while. Other than that, let's look at the statistics, which have really helped us in terms, and I can say from the onset that we have grown from leaps and bounds. From a position whereby in 2017 we had below 100, and up to last year we are doing close to 400 appointments, which is quite commendable. And this reinforces our position as a leader in terms of dispute resolutions and appointments in this field. So looking at, we have a 2025 summary that I'm going to highlight, and just allow me to share. I will just briefly just take us through the same. And from the onset, you can see that we had 371 appointments in 2025. Compared with 2024, I think we had 384. So there was a slight decline. But however, this month we have already dealt with about 30 or so appointments. So we are still on track. In terms of of the value, the CEO has said that it ranges from the little amount of 120,000 to billions of shillings. And the highest that we had for 2025 was a whopping 3.7 billion dispute. So you can see that it really ranges from as high as that and as low as we can get. What does this tell us? It tells us that disputes are diverse, and it tells us that wherever you are, as long as you are qualified, you are empaneled, and you're ready to take up, then there could be something for you. The other aspect about last year's is the distribution of the disputes that came through, and you will realize that in terms of the distribution of the quantum, you can see from that we have 1 to 50 million, which got the highest, close to 200. And the others, of course, we can see the billions are quite few. And the others are those that do not have a specific quantum, but it's maybe a dispute into partnership and a dispute into shares and all that. So we also deal with that. So it tells us that the disputes are quite diverse. They may not just be in terms of the subject matter being a value, but any other dispute are also considered. The other aspect that came through is about the methods. And again, arbitration as the norm is taking the lead. And as you can see, we had 97% being arbitration disputes that came to us. And we have mediation following with 2% and adjudication at 1%. So issues to do with arbitration, very, very critical. We'll also be talking about the arbitration clauses because it starts at that. The chair had mentioned about pathological clauses, and these are some of the challenges that sometimes we get along the way. I remember there is a dispute. I was appointed by another authority, appointing authority that I will not name. And you know that feeling that you get as an arbitrator, and when you see an email of appointment, first thing that one, that institution does not have the. For us, we have a nomination stage whereby we send you. You look at the dispute, you confirm whether there's any conflict, you confirm that you're competent in the area, and you confirm that you have the available time and willing and ready to take up the matter. Then you return to the chair, then the chair issues the appointment. In that other authority, it was a straight appointment. So as happy as I was, my happiness was very short-lived because looking at the documents, just looking at the arbitration clause, the appointing authority was not the one that was appointing, and I had to decline and return it to the authority and highlight that there is an aspect that they didn't capture well. Of course, it went to the other appointing authority, and that was the end of that brief. So what am I saying? Drafting of the clauses is very, very critical. As you can see, it is the mass of the disputes that we have. The other statistics that came through is about, yes, this is still about the methods utilized. You can see in 2024, it was also 95% arbitration. Adjudication that year was higher at 3% and 2% mediation. Status, the other statistics which is critical is about the status. We like to also monitor, even though we are an ad hoc appointing authority, we have that obligation to monitor how our arbitrators once we appoint them, they are conducting themselves and how the disputes are. And I must say that it's important as arbitrators, once you've been appointed, just keep us updated where the position is and whether you have finished the matter, if there is just the progress of the matter. As you can see from the status, the statistics show that 94% of the matters are ongoing. And then we have, that is from 2025, we have completed matters at 4%. It's important that we do a return after you close your matter. Why is it important as an arbitrator? One, it will tell us that you are now available for another appointment. But if we appoint you and you do not tell us the finality of the matter, either by consent or by hearing or otherwise, then we will still be noting that we had appointed you. So it's important you give us this feedback so that we can also capture it for our data. 2% of the matters collapsed, and you all know that this does happen for one reason or another. I remember my first appointment in the region of Mount Kenya, and I was very happy to do an arbitration here several years ago. When the parties came to me, we did a preliminary meeting, and of course I gave them my terms. Then I tell you that was the end of the arbitration. I later called, checked with the counsel, who is a friend of mine. I asked him, what happened to that arbitration? You guys, after the preliminary meeting, there was no word, no communication, no feedback. He told me, we heard of your rates, and it woke us up to go and settle the matter. But the objective was still met. I asked him, you should have come back for a consent. I do a consent, and then he said that the hourly rate was quite frightening. So there are matters that can collapse due to that, but in a positive way, the parties meet their objective out there by deciding to settle the matter on their own. But it is always very important to encourage such parties come back for a consent award, because you never know, you may be back to arbitration in future in case of any default. Again, nature of disputes in 2024, we can see that the diversity of the disputes that are there. Commercial, of course, commercial disputes takes the lion's share in excess of 250, followed closely by the construction industry and the others. We also have the labor matters, insurance matters, IT, land, DAB, and so forth. So the diversity of the disputes is quite enormous. This is just an extrapolation of the disputes diversity from 2017 to 2025. And again, you can see the number of disputes. No, this is the growth. You can see from 2017, we were below 100, steadily growing. You can see there was a spike in 2019, 2020, 2021, especially 2021, and you all remember this was the year of our Lord, courtesy of COVID, and definitely when merchants and traders and the business people had their disputes in court, and then one day the CJ wakes up and closes the courts, they realized they need to continue with their business. They need to continue with their relationships. So what next? You remember at that time, ADR, especially ODR, online dispute resolution, spiked up very, very much. And a lot of disputes were handled. So you can see, no wonder that spike. Then you can see there was a drop in 2023. I think when the courts were open, they again all decided to go, yes, we are back in court. and that we had that decline. But 2024, you can see the rise, and we are steadily at it at close to 400 disputes. So these statistics basically show our organic and natural growth in terms of the confidence that the public has in the Chartered Institute of Arbitrators, and the trust that they have in our processes and also in our arbitrators. So to arbitrators, I urge you that you always jealously protect that trust and that confidence that the public has in us. In terms of diversity, this is something that we really try to balance, but sometimes somebody said that facts are like a lion, and when you unleash a lion, it will deal with whatever it has to deal with. So these are the realities, and the lesson from this is to encourage. And in next, you will see that there is a constant growth in terms of the gender parity. But in terms of the distribution of the qualified arbitrators, you can see the chartered arbitrators are 12% of the total. We have 42% the fellows and 46% the members. As the CEO mentioned, the associates that's just an entry stage. So if you're an associate, please get up and move up the stream so that you can capture you. We are capturing this because these are the dispute resolvers that we have. So this is the stark reality. In terms of gender representation, ladies, girl power, where are you? The male are a whooping 80%, and female are 20%. Sometimes at the appointments at NAS, we struggle so much, and we really want to appoint women, but looking at the data, the available, we are constrained because I can tell you for a fact, once they are there, they are qualified, they fit the bill, we readily give the appointment. So this is just a call to action to the ladies in the house. Let's really take up this and go upstream in terms of training of the ADR and arbitration modules, so that you can get to a level that we have a gender parity. And I've said that there is light at the end of the tunnel because these are the mentees that we have currently. And the mentees are those that are now just about at the last stage to be turned out as to our role of neutrals, so that they can join the panel and be available for appointment. So I commend the recent, and I suspect these are the younger generation, they are taking up, the female are taking up. You can see we are now getting to a close of the gap. The male are 55% and the female are 45%. So well done to the ladies. So the future is bright, and we can only look forward to. This, I can tell you, is something that goes even deep into making Nairobi a safe seat. Some of the considerations, gender parity, do come in place. So if we get to this reality eventually, this will be a very, very good place and attractive to show that there is diversity and there is equity in all areas. Turnaround times. I know as arbitrators, there's always that arbitration file that you have that is still sitting there for one reason or another, either because of the parties themselves or because of yourself being very busy. But I assure you that this is very, very critical. I always remind the parties that come before me of the importance of Section 19, that we are all, this is a collective responsibility. We must ensure that there is expediency in terms of arbitration. It is only in expediency that we will help and attract more of disputants to come, because they normally come due to its advantages of confidentiality and also its expediency. So if it comes and it sits on you, I would really urge you that your case management skills, you have to really push the parties to move the matters. So these are the statistics in terms of the case turnaround times, in terms of days. Ideally, arbitrations, the ideal position is that it should not go beyond 1.5 years. And as the statistics are saying here, we have been trying that, but sometimes it can go over because of one reason or another. Another tool that I would recommend to you, and I hope you normally do, even when I get ad hoc appointments, even party appointments by consent, I always urge the parties to adopt the CIarb rules 2020. Those rules do wonders in terms of case management. We provided for the expedited arbitration. We provided for emergency arbitrations. We provided for basically everything. Every question that you may have, any handicap that you may have, you will find it in the rules. So as you can see, the number of cases, again, the statistics are showing commendable work done. You can see the 0 to 30 days. We have about the highest number. And again, something else is to encourage parties where the dispute is so clear in terms of documents. You really do not have to do a hearing. So a documents only arbitration is one of the ways that really expedites the process. And I would urge that you as the arbitrator, this is something that you can throw to the parties to consider. If it does, well and good. I have turned arbitrations in 4 months, in 3 months, because it was documents only. Everything is straight and clear. They let them submit on whatever else they want to submit, and you do your award. So this is very, very critical because it sells us out there. I would truly urge that we take control of that. The types of agreements and contracts in a dispute. Again, we can see the diversity. Agreements in terms of sale of land, sale of property, and all takes the lead. We have construction, the lease, debt, loan, supply, agency, insurance, partnership, employment, and others. Any dispute that comes of whichever nature, we will still allocate a dispute resolve. So let's be key in terms of how we manage that process. So in a nutshell, those are the statistics, and the statistics are encouraging. As I have said, we can only do better in terms of helping the institute and being good ambassadors of the CIarb, so that we can be the leading and the premier as we are in terms of ADR. So that is the statistics we wanted to share with you. At this point, maybe I can invite the CEO to take us through. You've heard a lot about mentorship You've heard a lot about empanelment, the role of neutrals. So let's hear about that. And then I can come back and do the issue of the clauses. They're very important, and also our functions as a CIarb, as an ad hoc. We said there comes a time that we become functors official. What does that mean? What does that portend? What are the challenges that come with it? How have we dealt with it so that we can still ensure that there is effective dispute management by our arbitrators? So CEO, you want to go for that a bit first, and then I can come back?
All right, thank you very much, VC, for taking us through the statistics. And as you can see, there has been a positive trend in terms of, if we look at 2017 and where we are currently, required and facing arbitration. And you'll also notice, and this is coming from the state of ADR research that we've done in the past 4 or 5 years, that yes, the Institute is one of the leading appointing authorities when it comes to arbitrations, but you'll be surprised to realize that the majority of the cases usually are party appointed. So, and I know the chairman mentioned about personal branding. So in as much as we are also incorporating you within our panel of neutrals, don't think that that is the end of it. And also it goes into ensuring that you're not only looking at the Institute as a source of disappointment, make sure that you're positioning yourself strategically, that the parties know that you're competent enough to take up these matters. Now, it opens us up to know what are the statistics in terms of our empanelment. The VC has indicated in terms of our membership, where are we and how do those numbers look like? So on your screens, I've projected the total number of members, that is the Chartered Institute of Membership Directory here at the Kenya branch. And I'd like to highlight the discrepancy or the huge difference between the ladies and the men. And it's not just to say that this is the only thing that we need to consider, but it also paints a picture and tells a story. Of all our members, we have 38 chartered arbitrators, 4 of which are ladies and 34 are men. So we're looking at less than 10%, I think, of chartered arbitrators. The fellows, we have 36 ladies, we have 141 men, a total of 177 fellows. Members, 256, ladies, 394, a total of 650 fellows. Associates are a total of 570, with 212 being ladies and 358 being male. Total number of members currently at the directory of the Kenya branch, 1,435, of which 927 are male, 508 are female. There is now the discrepancy, as you can see, in terms of how many of these 1,438 are on the role of neutrals. The role of neutrals, we've agreed, is the list that the vetting directory, as well as the vetting committee, as well as the chairman, relies on to make appointments. It's a fraction of the total numbers of the total numbers. And why is that? And that is now the conversation that we need to have. If you look at the diversity, and this also informs the statistics that the VC has presented, where you've seen that of all the appointments, only 20% went to the ladies and 80% went to the male. It is not because we are not gender inclusive, but because this is the numbers that we have to work with. Even as you look at the statistics, it's about 19% of the people in the role of neutrals are the ladies, and about 81 are men. So you'll see that we have 239, of which 49 only are ladies, 190 are men. Now look at the spread. We only have 4 chartered arbitrators, male, ladies, and 27 men, 31. Fellows, 14 against 76, 90. 31 plus and 87 members. So what I'd like to bring out is the difference, and especially at the higher levels of chartered arbitrators and fellows. We have 38 chartered arbitrators, but only 31 within the role of neutrals. At least 7 is not that bad of a number. But when it comes to fellows, and this is where the biggest problem we have, is that we have people who are qualified and they have nothing literally between them and empanelment, but they are yet to come and get empaneled. We're looking at a difference of almost 60 something people, or 70 something, that is almost 80 something, 87 people that are yet to be empaneled, and they're at fellow level. So it brings us to the question of what is it that you need to do to get onto the role of neutrals. Number one, the role of neutrals, as you've seen, doesn't accept associates for obvious reasons. As the chairman indicated, as the VC indicated, the skills that you have at associate level is still very limited to be able to handle disputes comprehensively and conclusively. So you need to continue enhancing your skills. So the policy that the Institute operates, and this is very important, and I'd like each and every one of us listening in to be aware, if there's nothing else that you're going to take out of this, and especially for those who are yet to join the role of neutrals, is this. There's a policy that was rolled out in 2021, if I'm not wrong, or 2020, where it was decided that there's need to have some sort of quality assurance that not everyone who has been trained essentially goes directly into the role of neutrals. And for those who've taken the training, you'll appreciate the fact that, yes, we have taken you through the theoretical aspect of it. You need exposure as to the experience part of it. And that is why we're very keen on mentorship. For every appointment that we make, we ensure that we pair a mentee with the mentor or with the person that we've appointed. Why? Because it is important for the younger and, newly, I wouldn't call it generation, because you also have senior people who are getting into arbitration at a senior age. But the people who are new to arbitration also get to experience arbitration firsthand. So what the pre-qualifications for you to join the role of neutrals are is, number one, you need to be at member level and above. Number two, you need to be a paid up member. Number three, you need to have concluded or have gone through mentorship. And this mentorship is where you sit in an arbitration until conclusion for at least 2 arbitrations. So once you write to us requesting for mentorship, we will place you with at least 2 or sometimes 3 arbitrators. Game of numbers, but at least we need 2 letters of recommendation from your mentees or from your mentors indicating that truly you have gone through the mentorship process and they feel that you're ready to take it up. And number 3, we introduce something called the induction training or the role of neutrals induction program, where we give you the soft skills of managing or at least navigating the dynamics of arbitration. You'll get to appreciate that the theory we give you in class is very, very different from what you experience, and especially when you're dealing with parties and they're bringing new things every day. So we need to, part of the induction is to arm you with these soft skills, arm you with the knowledge, arm you with the tools that you need to navigate the experience and the practice and procedural aspects of arbitration. So for the members who are within the 90, the fellows who are within the 87, reach out to us, find out how is it that my name is not on the role of neutrals and what is it that I can do to ensure that I get there. For those who are seeking for mentorship, if you're at member level and above, as you can see, our numbers they're not doing badly. And the VC has already given the number of appointments you've so done between January 1st and now. It means that for every one of those appointments, we have to match it with a mentee. At some point last year, there are so many arbitrations that we made that we didn't pair with mentees, and we would get calls from members saying, "Hey, I've gotten a matter but seen a mentee." And it's not that we didn't want to place, but it's because we had exhausted our list of mentorship. So in this case, those who are seeking mentorship, write to us, ensure that you're already paid up, you're in good standing. write to info@ciarbkenya.org. We'll place you on the mentorship role. And what happens is that first come, first serve basis. So for every appointment we make, we will place a mentee in there. Now, we have gone ahead and curated a standard way of mentorship. Those who've gone through mentorship before, we just let it as you've been placed by this person. So it was up to you and the mentor to assess and see what exactly mentorship would mean to you. So in this current year, we have curated a mentorship logbook that essentially creates some sort of expectation and guides as to what is it that you need to, what skills you need to learn, what is it that you need to be exposed to, what are the things that you need to do within that mentorship period, so that at the conclusion of it all, it becomes of value not only for you, but also value to your mentor, because then they know what skills they need to impart on you. So that is something that we're going to effect in the course of this Q1, where now for all subsequent mentorship, they will come with a mentorship logbook, and then the mentee and the mentor can both participate in it. And then we can have like a quality assurance structure that ensures that everyone across board gets to experience mentorship in a standardized way. Now, if you look at these numbers, it means that there's something that we require to do, especially for the fellows and the members. So for the members who have already started their mentorship or they are looking to complete, the next step is induction training. Previously, we would run the induction training once a year. Now we're doing it twice per year. We just concluded one sometimes in November. We will have another one in March and another one at Q4. So those who are concluding their mentorship can then come on to this induction training and then now make the application to then join the role of neutrals. There's something else that we've also introduced, or something that has been there, and I know you may have, for the members in the room, you may have had access to it, which is the empanelment certificate. The Institute, as a thought leader, aims at creating an environment that essentially makes it easier for dispute resolvers to be met with arbitration cases, or at least to ensure that the people who are qualified as arbitrators get the matters. We've had instances where people who are not qualified, probably they're just within the legal sector, are masquerade as arbitrators, and then they do very weird things out there, which then have negative impact to the market. So as part of that solution, what the Institute is doing is to ensure that we have partnered with the major appointing authorities in the country, or other appointing authorities in the country, institutions such as the LSK, as well as we have the LSK, the Architectural Association of Kenya, IQSK. We share MOUs with these professional organizations. So our aim is to not only now, address issues of capacity building, but also address issues of appointments. How are we doing this? Since we are the custodians, given that we are also the trainers, since we are the custodian of the competent dispute resolvers in the country, we want to share this list of qualified dispute resolvers to any other appointing authority to ensure there's some sort of coherence, and also ethical conduct, and ensure that only competent dispute resolvers are handling these disputes. To avoid the issue of those masquerading as arbitrators, but they are not necessarily arbitrators, they do not belong to any specific body. So we're using the empanelment. So once you join the role of neutrals and subscribe to the empanelment certificate, personally, you can go to any one of these, whether they are party appointments or whether they are other institutional appointments, and present your certificate. Using your empanelment certificate, you can also apply to these other international institutions to be on their panels. So the empanelment certificate is critical in that way, because it is the Institute's way of trying to create some sort of order within the market of dispute resolution. So part of this, and this is something that we've already engaged with LSK, is that every year we will share our panel of neutrals with them. and especially those who are in good standing, so that should then applications be made to these other ad hoc appointing authorities, then they will have a list of competent dispute resolvers to choose from. So then the chances of having all these other people masquerading as arbitrators or appointments of people who are not necessarily skills and the competencies goes down as well. So that covers the issue of empanelment. And I'm looking through our list of participants, and I can see most of them are members. Now that I've seen the Anish is in the room, Anish is one of our chartered arbitrators who is based, I think, in India, if I'm not wrong. That means that our panel of neutrals is not just open to the Kenyans. We have currently, of the 239, I think right now we have about more or less about 15 to 20 who are non-Kenyan. And should matters align, as we have said, they also get to receive matters. And I know that's a question someone had asked me earlier. So it is not something that you're only doing for Kenyans, yes, but we are also expanding this. We have Ugandans in the room, we have Nigerians, we have someone from the UK as well. We have Anish who's from from India. And as at this year, these are the statistics for 2025. As of this year, we've had about 15 people coming in from the Asian community also joining our role of neutrals. So what we are aiming to do with all this is to ensure that there is synergy between these other countries, because at the end of the day, at the Institute, what we aim to do is profile our members even within other particular panels, and especially at the international level. We're not looking only to serve the Kenyan market. We're also looking to profile our members to serve in the rest of Africa, the rest of the world, whether it's Asia, UK, and the like. So ensure that you're well in good standing. Ensure that whenever you hear of these other opportunities that we have curated, you're part of them, so that you get to derive the most value out of our dispute appointment services. Yes, the dispute appointment services is anchored here, but we're looking to profile our panel of neutrals in different jurisdictions as part of our value proposition to our members. VC, unless there's something I may have missed out in terms of empanelment, maybe any questions? I can see there's some questions on the chat. Any questions you may have on empanelment and how to get onto it? I see there's a question, Mary, how do you get to know if you're on the roll of panel of neutrals? We will publish this list. So together with the list of, together with the caseload that we have shared with you, we're going to publish the list of neutrals, so that then you know whether you're on it or not, and then get in touch with the Secretariat to address why you're not on it. And then also we will facilitate in terms of giving you the requisite information to get onto it. VC, is there anything else that you'd like us to address at this point? I can see that some of the questions are being addressed on the chat. There's a question from Nyalita. How can the Institute appoint a non-member to arbitrate a case? Seriously. Everyone who's on our list is our member. And let me make that clarity. Everyone who's on the CIarb's panel of dispute resolvers or on our role of neutrals is a member. And so they first subscribe to us, and you'll find that given that the Chartered Institute is a global institution, you'll find that even these other people coming in from the rest of the countries I've talked about, they either have those countries as their primary branch of the Institute, or they have the Kenya branch as their secondary or primary branch. But the bottom line is everyone who gets onto a role of neutrals is a member of the Chartered Institute of Arbitrators. So allow me to make that clarity. There's a question from Rina. Are there any actions you need to take before you share the panel list to other bodies, especially data protection? Yes, yes, yes. So number one, not only do we share these lists, we don't share the lists in terms of this has specific data that we do not give, and especially when it comes to contact details, we will not give your phone number and all that. We may give your PO box because at the point at which every member was applying, or most of them, they usually give consent that their data can be shared with other partners as long as it's in furtherance of dispute resolution. But also you realize that we also publish this list on our website. So you once you get onto our website, you're able to download the vetting, we call it the vetting directory. You're able to download it, but you'll not get specific information about those members unless now then you come back and request for it, and especially if we are barred by data protection laws to share it. There's a question from Kenneth Miriti, or it's a comment. Kenneth is saying that there's a listing, but it is not easily accessible, visible to potential disputants independently seeking dispute resolvers, nor the general public for information purposes. There is a need to improve the search mechanism and visibility. Thank you, Kenneth, for that. That is actually one of the things that we're currently working on. And maybe you may have received an email from Redemptor, and especially those who are qualified, asking you to update your credentials on the website. So essentially, it is to make you more visible, is to make you more reachable, or even I can use that. But in terms of the general access to it, we've taken note of that, and we'll look at it and see how best to enhance that aspect, that they can easily be found by anyone looking at that.
If Evelyn, allow me to ask a question. I'm unable to raise my hand. Have I lost her? Sorry. Oh yeah, they have lost.
Yes, Judge, you can proceed. You can ask the question.
Yeah, sorry, we've just lost.
Yes, I think there is something, but she will come back.
Yeah. Two, three things. Did I understand Evelyn to say that membership and appointments are conditional to subscription in London? I think we'd better make that very clear to members. Secondly, what can we do to capture statistics on all arbitrations or all disputes resolved by members? The need for statistical data is to ensure that we tell the world what we are doing here, just so that our large numbers are able to inform the need to resort to ADR. But I know lots of the appointments may also be private. Is it possible to have every member each beginning of the year to confidentially disclose how many arbitrations have been done, of course, without necessarily, or rather, without having to prejudice their opportunity for appointment? Just to give us the statistics to see how are we performing, because those large numbers might win favor with the public. Now, I get quite concerned with our quality of the arbitral process and the quality of our arbitration awards. And I speak as an examiner for London seeing what we are able to do, what we are not able to do. What are we doing? Are we encouraging members to participate more in training forums, maybe workshops, probably mentorship of the kind of quality that will see them doing their work better? And I recommend this knowing that the quality of our arbitral process, how we handle the entire process, and the quality of our arbitration awards will either portray members of the institute as either quacks or as dispute resolvers of high quality or people to go to. So we need really to think about that. And finally, to what extent do we go to publicize the work of the Institute to the public at large so that they know that we exist and that this is what we offer over and above the judicial institutions that are open to them. Sorry, that's just what I wanted to raise, and any of you could answer my questions.
Thank you very much, Judge, for those very incisive questions. And this comes, I know, from a very informed point of view, whereby when you sit at the bench, some of these awards do come to you. And I can assure you that we are doing a lot towards this area. Let me start with the first question in terms of membership. Yes, I was to address this. Members, for you to be in the role of neutrals, one of the qualifications that we look at, the bare minimum, is that you must be in good standing with London. What does that mean? If you are a member, if you are a fellow, if you are a chartered arbitrator, you must have paid your London dues. Somebody asked about a certificate of practicing. Yes, London does issue a practicing certificate for the year. I would also encourage you to be paying before the end of January because there is always a discount of 5%. So that is very, very critical. If you're looking at the role of neutrals, you're not finding yourself there, it is because you're not paying your dues in the UK. Remember, we are only a branch. The headquarter is UK. We must pay the subscriptions fee. By that, then you will get to the role of neutrals. Then you can be allocated. Further to that, though this is voluntary, we also have a voluntary membership fee that is paid to the branch, voluntary. For the goodwill ambassadors and those who support us, you pay. Chartered arbitrators and fellows, we pay 10,000. Members pay 8,000, and associates actually there's no requirement, but that is on voluntary basis. So that is the first critical thing that you must meet, a payment of dues. Secondly, your question, Judge, about statistics and capturing of data. Yes, and we have, that is why we are initiating a lot of tools of onboarding and also offloading. Once you close on a matter, we'll also be issuing a tool, just a simple tool for you to fill, and also for the parties to fill and give us a feedback of how the process was, so that we can, one, be able to capture the data in terms of the arbitrations that are out there, and also the members feel, the parties feel, what is their feel, what is their feedback about the arbitral process. The private appointments, it's a hard one to really track that, but because the objective here is to make Nairobi a safe seat, an attractive seat to the international world. So if our members can also volunteer that information to us, so that we can capture, we can have a database of what we are doing in terms of arbitration, it can really help us. And I know what you mean, Judge. So we do also encourage that. The third one was in terms of the quality. And yes, indeed, these awards do come to you when you sit at the bench. The arbitral process, how do we conduct our arbitral process? The case management skills, what is the feedback from the parties? The awards that we are writing, what is the quality of the awards? Can they withstand the test of being challenged? We are doing a lot in this area, continuous professional development. I know as the CEO will come back and tell us about the CPDs that we are bringing back and the requirement for you to qualify for the next year. So as a bare minimum, continuous development is part of us. We also engage in peer lounges whereby we call very established and well-known arbitrators in this area, and I'm sure this year Judge will be one of the panelists very soon, where we sit down, we exchange ideas, we share experiences, and learn from one another. Because truly, this is a world that we really need to grow one another. So we are doing a lot: the peer reviews, the peer lounges, and the continuous professional development that we are rolling out. And the last one is about publicizing. Yes, this is also another critical area. We are doing a lot as CIarb, but is the public out there aware that we are doing? I've just seen a comment about our website, some accessibility and such. We appreciate such feedback because we take note of that and we take the steps. So we are very keen. And that is why last year we did the inaugural ADR week, a whole week of just showcasing what CIarb is all about. And it was quite a success. So those are some of the ways that we are coming up with to ensure that we do publicize. Our partnership with the judiciary, we are joined by the HIP, and we've been very good partners going forward. And that is something that we also want to embed and nurture. So that by even the fact that our judiciary, when you look at the Supreme Court, they are all fellows. That speaks volumes out there. We go out there and we are commended out of that, because it tells even the international community that when the matter spills over to court, at least at the very apex level, we have persons who are well grounded in terms of the arbitral process. So thank you very much, Judge, for those very useful questions and comments. We take them in, and I assure you that we are working on this. CEO, thank you. Thank you very much, Judge. CEO, are you back?
Yes, VC. Sorry, I think connection problem. I dropped off unceremoniously. Maybe I can also add on to your answer as to the statistics on cases going to arbitration that Judge mentioned. It is also part of why we started the initiative on the state of ADR research in Kenya, the biannual research that we conduct. That is in trying to capture the data. Now, the problem or the challenge we get is we write to members and we find that most of them are non-responsive, but it's something that we'll keep getting at because we know why these statistics are important and why we need to capture that, because they ensure that we have the data required to plan for the future. So it is a very, very critical area. And whenever we ask these questionnaires or whenever we send out some of these requests, kindly engage with us, because at the end of the day, we are looking for data that will then aid us in ensuring that the service delivery, number one, the profile, the environment that we're creating as an institution is ideal to enhance dispute resolution through arbitration and ADR. There is a question, VC, on the chat that maybe we can address. I know we have the last aspect, which is number one, CPDs and the issue of the arbitration clauses. Alice Njomo is saying that, thank you for the informative presentation. Are there any plans to integrate technology or data analytics in the dispute appointment services to strengthen transparency and merit-based arbitrator appointments? Alice Njomo, yes. We have that as part of our strategic plan for 2030 plans, where we are looking at how we can be able to move with the times these days, digital, AI, and all that. So there are plans into it. We are yet to roll them out, but it is something that is at the back of our minds and something that we're looking to implement in the coming strategic cycle. There's also another question from Kate. I was asking about the empanelment certificate I mentioned. We must get an annual CIarb certificate, but what about this empanelment certificate mentioned by CEO? Is that annual and separate from the, I'm assuming that is from the CIarb annual certificate? Yes, Kate, this is separate. So as VC indicated, every member who's in good standing essentially is defined as a person who is paid up in London. You also mentioned that since that supports your membership, since CIarb UK is the one that manages our membership, all of us, at the Kenya branch, as we're not ideally required to, collect subscription, we instituted something called the Membership Development Fund, which is voluntary, that supports the local activities here. And we've been very privileged that most of you have been paying into it and supporting our initiatives, and that's why we're able to gain the impact that we've been giving. In addition to that, in 2023, the empanelment certificate was introduced. And this is the one that now says I'm a qualified, panelist, or I'm a panel member of the Chartered Institute of Arbitrators Room of Neutrals, that you can then present to any other body that shows that you are indeed a practicing dispute resolver. The certificate that you get from London is to say, I'm a member, I'm a fellow, I'm a chartered arbitrator, or I'm an associate. So this the empanelment certificate shows that you're a member of this particular panel. So if you're a member of the CIarb panel, for example, you may, I'm not so sure about the structures there, you may or may get a certificate there. But it is something that shows you, not only are you a member of the Chartered Institute of Arbitrators, but you also are qualified dispute resolver, which is now separate from that. And you can get a certificate, you can be empaneled on the arbitration panel, you can be empaneled on the mediation panel, you can be empaneled on the construction adjudication panel. So the certificate is only 10,000 shillings. But it's at your discretion, it is not mandatory. It's essentially something that you do to profile yourself and to market yourself out there. VC, I think there's a question that maybe you can address. It's from Emmanuel. I don't know whether you may have addressed it when I was away. In light of the conflicting decisions in regards to the employment disputes, where some judicial authorities have held that the same cannot be arbitrable, yet in others they have upheld arbitration as valid ADR for such disputes. What is the current institute stand in consideration of these jurisprudential divergences? Please.
Yes, thank you. Thank you for that question, Emmanuel. Yes, this is something that is still out there in terms of debate. And in terms of the judiciary, the best way to settle that is the appellate way. So I'm sure, I know there is a pending matter before the Court of Appeal on the same. So if they will wait until they pronounce themselves. But as a dispute resolving premier institute, for us is that arbitration and party autonomy is critical. So if parties willingly agree to put a clause, then it is really up to them, because they have that autonomy to make that decision. And I personally, it may not be the institute's position, but personally, I do not see a problem in doing that. But that is something that we will wait to see. Probably it may go up to the apex court, the Supreme Court, and we'll have a definitive answer as to that. However, does it bar you from arbitrating? To me, I don't see a problem. If there's a dispute that comes, it has that clause, the parties have agreed to appoint you. This is ADR. Proceed with it. CEO, I don't know whether I can continue. I see I'm mindful of the time. Had you finished? Can I touch on the issues of the clause and the functors official?
Yes, please.
Okay. So members, we had mentioned the issue about the clauses, and the importance of the drafting stage of the arbitral clause is that you do not want to draft to parties a clause whereby the time comes that they really need to actualize that clause, they find that they have another dispute of interpretation of that clause. Sometimes a dispute can say that, yes, dispute resolution shall be by way of arbitration. And it leaves at that, and it says by the arbitration laws. Leaving at that, it is so open and anyone can have any other. So does it mean we go to court for the court to appoint the arbitrator? Does it mean we sit down, we agree? So you will have a dispute within a dispute. So it is always important to have a multi-layered clause. That one will give the party autonomy, the choice to first agree. Many a times they may not, sometimes they may agree, well and good. In default of agreement, then have a definitive way of appointing and kickstarting the process. Have an appointing authority. Talk about CIarb, the chair to appoint an arbitrator. Because again, if you leave it at the parties appointing, if they fail to appoint, then they are stuck at that. One proposes arbitrator A, the other proposes arbitrator B, and they are stuck. They cannot agree. So what next if the provision was not back-to-back? So avoidance of these pathological clauses is very, very important because it helps us in terms of really dealing with the appointments accordingly. And some of the challenges that basically that we face in terms of being an ad hoc appointing authority. And this is touching on also our functors official. Functors official means that when we are ad hoc, there is a limit that we can stop. Where is the limit? The limit is at appointment. Once the request is made, the documents have confirmed that we are the appointing authority. You've made the requisite fee. It has gone through the vetting process. We have gone to our directory and appointed an arbitrator and communicated to the party. The arbitrator has accepted and communicated to the parties. Then we are functors official. Why? Because it is ad hoc. Now it is in the hands of the arbitrator. We have had very many parties come back to us with a number of complaints. One, delays. Parties come back and say that there is a lot of delay, the arbitrator is non-responsive. What do we do? Basically, they come back to us as the appointing authority. I will talk about what we do, despite the fact that we are functors official. Non-communication. Arbitrators always keep the communication open. I remember during COVID period, I was counseling an arbitration, and the arbitrator went dead silent. Yet we had a lot of guidelines from CIarb, from Africa Arbitration in terms of moving matters virtually. So I proposed to them about that, to call for a virtual meeting. They never did. I had to go to the extent of now, when courts opened up, making an application for removal because the other party also refused to, we jointly remove, and eventually they were removed. So it can really prolong the process for no good reason. So non-communication, always be communicating to the parties and keep them abreast. The other issue is about case management, that the arbitral process, the arbitrator does not seem to be in conduct, is being swayed by one party, by the other. and they are losing confidence in the tribunal. They come back to us that this is the issue. We have tried. We are coming back to you to assist us. The other is conflict of interest, and it is imperative upon us arbitrators. Let's live to our true calling. Whenever there is a shred, an iota of conflict of interest, we all know the IBA principles. It may be in the green, it may be in the amber, it may be in the red. Of course, in the red, you stop and leave it at that. But even in the green, you have a duty and obligation to disclose it, that I have seen this matter. This is the conflict that is there, even though it will not affect my independence and my impartiality, and you leave it for the parties to decide. Once you disclose that from the very first, for example, when one of the counsel is a former classmate, of course, we are lawyers, we are arbitrators, we will interact with this with parties, but it is good to disclose it in advance, because as you go along, when a party realizes and gets a photo of you attending an Odoni for the council many years ago, it can be brought back to you, and it will not sit nice. So always be the one to disclose in advance. When you disclose, parties will be comfortable. They will see that was just in the past, and it cannot affect your professionalism. So conflict of interest, very, very key. Even where you are attached, as we appoint you, how do you relate? Is there any possible conflict within the dispute that you've been appointed for? Disclose it. If you don't, we are receiving those complaints that, oh, there is this conflict. What do we do? Matters costs, very interesting. We've received very exorbitant hourly rates, exorbitant hours. There have been timesheets that reading an email and perusing a document of 20 pages, that it is taking 20, 30 hours. So again, as arbitrators, let's just be true to what we are doing so that we can manage. And this is why the debate of arbitration is becoming expensive, is going. You have to help us to protect this area. The issue of rising costs and rising nature of arbitration is, it boils down to you and I as arbitrators. What do we do? How do we charge? Are we true to it? The other one is professionalism. Of course, once you may be an acquaintance, but once you start a matter, that just ensure that there is that boundary that will not be crossed, and proffer that professionalism to the parties so that they can have confidence in you. The other one, of course, issues to do with integrity, your ethics, issues to do with umeonwa. So let's, as arbitrators, let's avoid that. Corruption in arbitration is a big debate globally. Whether it is a perception or not, it's still out there. But even that perception does affect the process, and we are receiving this feedback from the parties. And the other one is appointment. At the time of appointment, and that is why we have resolved to come up with that detailed, efficient tool of onboarding. You want us to appoint, we send you that form so that you can give all the information that is necessary. That information will help us a lot. We have experienced whereby we appoint somebody and we are not privy to some facts which are out there. They are very, very apparent, and it ends up becoming quite an issue. For example, we all know that the first port of call is parties agreeing on appointment. So there will be exchange of proposals. Send to us your proposal, we exchange. So you may have been named out there as a possible. If we do not know that, we will just come to our directory and we see that you're befitting we nominate you, and the essence of nominating you is for you, again, your integrity, to tell us that I had been considered and the other party declined. But we are having such instances whereby somebody accepts. Once they move into the arbitration, then they say this was a name that was proposed, and it becomes an issue. They've already been clothed with the jurisdiction, so there's a deadlock there. So how do we deal with this? As I said, we are functors of issue. At appointment, then we leave it all. The arbitrator assumes jurisdiction and runs the show. We expect that you will do it in good faith. We appointed you in good faith, that you will do it in good faith. We expected that we had all the information, but such happens. What we have done, even though we are functors official, we have an obligation to ensure that at least the name of the institute is not tarnished, because if it goes out there and the arbitration is not going well, it will still come back to us. So in our own ways, we do an informal communication. You are our member, we will communicate to the arbitrator, try to reason with them. Some have actually accepted, and you tell in these circumstances, you're advised to just recuse yourself. And some have taken that advice. But we do not have any obligation, but it is for the protection of the institute that we do that. But in the long run, what is the way out? As I said, we are a branch. Headquarters deals with everything else, even matters ethics and discipline. So if there is a complaint to be made, then the formal complaint goes to the UK, London. You can imagine how tedious and expensive that process could be. This is an issue we've been trying to negotiate with as branches all over the world with the UK, but they still hold on to it because many a times it can be seen as encouraging in that we do not have any decisive foundation to take steps in terms of discipline and taking errand members and calling them to order. So we really urge our members to be of a very good standing and to project the good name that the institute has, and ensure that the trust and confidence that by and by we are getting, not only nationally, regionally, and also worldwide, that Nairobi is becoming an attractive seat for arbitration. So that is what I wanted to add on so that we can have a back-to-back scenery of what the arbitral process, the appointment process is all about, the feedback that we get, the challenges that we are facing, so that you as arbitrators be able to ensure that you help us in terms of being good ambassadors out there. Unless there's something else I've left, CEO, I can give it back to you to handle the CPD as we wind up, and maybe the chair. CEO.
Thank you, VC, for that session on the bit of the institute being functors official and looks like go ahead. This next part addresses what Justice Lebuta indicated as to the capacity, the continuous building of capacity of members. You'll get to appreciate that as professionals, you need constant refinement in terms of your skills. You need to constantly hone your skills, and that is done through continuous learning. And the Institute, through various platforms, through various activities and initiatives, is looking to provide that platform for all our members as well as those interested in dispute resolution and ADR. How are we going to do this? We have curated a calendar. Number one, we have the standard pathway training. So those who are seeking to move from associate to member to fellow to chartered arbitrator. We have that pathway training where we take you through the CIarb curriculum until you get to the level of fellow, and then now with the experience you get to chartered arbitrator. In addition to that, we have the events, CPDs, and non-pathway calendar of activities and trainings. And we are spreading them through webinars such as this, though this being an informational webinar, it still forms part of refining your skills, because if you didn't know about the appointment services, then you are more aware of it now. We have skills refinement, and VC made reference to it when he said, Judge Buta, we may be reaching out to you very soon as to how we are going to enhance the skills, and especially when it comes to arbitral processes and procedures of members seeking to deepen their knowledge in specific areas, whether it is managing interlocutory issues, whether it is cost and interest, whether it is preliminary issues in arbitration, writing of awards, you name it. So those will be skills refinement, mostly targeted at members across membership, fellowship, chartered arbitration, mostly membership and fellows, aimed at, I know we did this at module 1, for example, but then this is an in-depth, dive into a specific skills refinement. And in this case, we'll be involving our senior members as well as our partners within these other international arbitration centers to enhance or to take part in those activities. We'll also be doing aspects around roundtable, where we are engaging sector-specific areas. So we will have, for example, at the end of next month, we'll have a roundtable within the insurance industry. So it is our own way of trying to understand what is it that the insurance sector needs when it comes to dispute resolution and ADR. So we will engage with professionals within these specific areas. So members such as, and I can see on the call, Mr. Asif Karim, who's in the insurance industry, they will be part of those champions to be part of these roundtables where we bring stakeholders together and can have those candid discussions on how we can be able to provide solutions within those specific sectors. We have, as part of CPD's events and activities, so as you well aware that arbitration circle is quite small, whether you are here in Nairobi, whether you're in the UK, you're likely to get someone you know. So to ensure that, and given that we know that it's through your social circles that you're able to get more work, number one, but also you get to exchange ideas, thought leadership and all this. We are also promoting networking activities. These will be done through cocktails, membership cocktails. The VC mentioned about the Peers Lounge, where we have the fellows and chartered arbitrators, the members forum, the associates forum, and something exciting coming up on the 20th of February. We have the first membership engagement where we are hosting the CIarb Global President here in Nairobi, and he will give a lecture. Initially, our calendar had indicated the Peers Lounge, but we are also inviting the rest of the membership cadres to be part of the inaugural or the maiden speech by the CIarb president, who actually got into office this month. So this is his first maiden visit of all the branches in the world. He chose Kenya as his maiden visit. So we'll have a public lecture on that day. So those are some of the activities that we are, or the platforms that we're using to ensure that members have access to CPD platforms so that they can continuously enhance. And what we are doing on our side is ensure that we're doing we're abreast with the trends and times, so that the content we are curating around those platforms is essentially timely, is relevant, and of value to you. But it need not come from us to you. We are also open to feedback from members. When you have an interesting activity, when you would want to host a webinar, this is something we've done even in the past under host a webinar, or what is it called? What we were doing where we invite our members to, through a partnership with our members, we can co-host webinars on specific areas. So we've done one on IP, we've done one on sports arbitration. So any other agenda you would want us to address that you feel that has not been addressed within our calendar, we're inviting you, let us have this, because it is a mutually valuable experience where from where we sit, we can be able to curate some of these programs, but we also have a ear on the ground to ensure that we also get to address some of the things that you would want us to address. Notwithstanding the conferences, our international arbitration conferences, mediation conferences, this year we are introducing construction adjudication following the demand we got last year from the CIarb. So those are some of the activities that you can be able to gain CPDs from. So as a member, we have rolled out the CPD. Actually, the CPD policy has been in existence for some time. What we want to do is ensure that you're compliant with it. So even as you're looking at the appointments, at the point at which you'll be looking at appointments, you'll be looking at, are you abreast with all this information, and how do you do that? How many CPDs have you so far done? So all chartered arbitrators are expected to get 25 points, fellows 20 points, members 15 points, and associates 10 points. This webinar, the webinars that usually hold for 2 hours that are free, it's about 1 point. You'll have some trainings that have 3 points. You have conferences maybe at 5 points. You have some trainings that have 5 points. And also we are working with our partners so that we see whether we can have some sort of an engagement where we get to recognize the CPDs within the institute as well. So all this is to ensure that members constantly hone their skills, they're abreast with the information, they have the updated skills and competencies to handle the work or the demands of the work of dispute resolution. Now, in terms of how to go about it, we are currently in the process of institutionalizing an ERP system, so that is still in the works. So it will become very easy for you to update your CPDs after some time. So that is the assignment that we're currently doing for Q1. But so far, if you request for your CPDs over the period, our membership department through Redemptor's desk is very keen and will always give you those particular points that you've garnered maybe from last year or 2024. So we always record every time that you attend a particular event, every time that you attend a particular training under the CIarb, we record those CPDs for you and we have them in our databases. So we are anticipating coming to very close future, we'll be able to do that now more efficiently using the system that we have just mentioned. I think that captures the aspects of the CPDs. What maybe I would like to highlight is that in the next week or so, we are hoping to continue with these ADR stock discussions. And the next one that we'll be addressing is in the event that you find yourself having either as a party representative or even as an arbitrator, a small claims in arbitration. From our statistics, we've seen there are 120,000, and you're wondering maybe that is your first, 10 hours. So how do you handle such? So we'll have a webinar on strategies to manage small claims arbitration. So from the perspective of, because I know we have lawyers in the room who are responsible in drafting, what considerations do you make as you're drafting these arbitration clauses, looking at the quantum that you have in your contract? Is arbitration always the solution, or can we also bring in aspects of mediation, aspects of conciliation? Small claims is another platform, although now I'm not really looking to promote that, given that we are in ADR space. But at the end of the day, what we want to do is promote access to justice through arbitration and ADR. So that is the next talk that we have. It will be hosted by our Chair Emerita, who was responsible in drafting the expedited arbitration rules of 22, which forms part of the 2020 CIarb rules. So make sure that you're also part of that conversation. And we'll also share with you our calendar of activities so that you know where to plug in some of the trainings that we have, and especially with partnership institutions. And VC, maybe I can highlight that moving forward, you've heard that part of our mandate is to ensure that we are preparing you for international arbitration platforms. We have ICSID coming in March. They'll be flying in from Washington, D.C. to host a training on investments arbitration for us, members of CIarb. So make sure that you're also part of it. I'm pretty sure you've seen something of that essence on your emails. Be part of it, and especially if you're at member level and above, we are preparing you for the future. So the least you can do is take up these opportunities when you have such great deals. If you do the same training in Washington, D.C., you're going to pay about $10,000. We're doing that at a fraction of the price. So let us take advantage of all these opportunities that we are making available for you. Because at the end of the day, this is our space, and we need to do everything that we can to ensure that it is a great space to operate in, even as we manage the dynamics of it all. VC, I don't know whether there's any other question on the chat, or maybe someone would like to say something. We can take the next 10 or so minutes if that is something that if there's any burning question or anyone with comment, so that we can then declare this closed.
Thank you, CEO. I have attempted to answer most of the questions, unless there is anybody who may want to ask a question, but I think I've covered the questions that were in the chat.
There's a question here from Dubi, sorry, Mukwana. He says, can CIarb Kenya consider offering the diploma in international arbitration? I'm thinking this is the one that CIarb London does in partnership with Oxford. Is it the one? VC, what do you think?
Yeah, yes, I believe it's, yeah, he has confirmed it's the one. You can address that since you're a beneficiary.
All right. I think it's something to think about. We are innovative, if not for anything else. So I don't have a concrete answer, yes, but it's something that we can think about, and seeing how it falls in the dynamics of the structures around training with London. I think it's something that we can be able to explore. So give us time, and then we'll get back to you. In the meantime, some of the trainings like the one that I've mentioned with Exit, you realize it's more or less in terms of the similar content. But we can see whether we can partner with either Oxford or similar organizations such as it to provide that diploma in international arbitration.
Yes, just to add on what the CEO has said, many of these, it all depends with the numbers. And if we have numbers who are interested in such, I know it's very expensive to do it in London, the collaboration with Oxford. But CIarb Kenya has come to a level whereby if we can lay a proposal to London, and we are able to demonstrate that we can actually have the numbers to pull this, we can actually do it. So it's good to see that there is interest in this area. And as the CEO has said, we are quite innovative, and this is something that we can actually roll out if the numbers are there for the cohort that can start it off. Thank you.
Opportunity to raise any question. There is a comment from Engineer Basil. For everyone in the room, and sorry to put you on the spot, Engineer, he's one of our international members, maybe logging in either from the US or the UK. A very impressive and enlightening session. Thank you, Chairman and Executive, especially the CEO. Thank you very much, Engineer. We really appreciate that. And thank you for the support and flying the CIarb Kenya flag very high in your areas of influence. I think, VC, that marks the end of it. I don't see any other question. what we can do is, I know someone has asked about the recording. We can see whether to put that together, and the team here can be able to share with everyone who has registered for this. So we will make that available to you in the course of the day or tomorrow. Allow me to take this opportunity to move a vote of thanks. Number one, to the chair, VC, for being excellent in the presentation and, providing this particular platform and even the idea behind this, as well as behind the work that goes on to these disputes appointment services. The Secretariat, who are also available here with us, but most importantly, for all the members and the non-members who've joined us. I've been able to count at least 5 countries represented in this call today. That shows that this is truly a great initiative and also something that is of interest to many people. Thank you very much for your time. Thank you for the questions. Thank you for the insights that you've shared with us, the feedback. And we are hoping that this being the first ADR talk in the ADR talk series for the year, that you'll join us even more consistently until the end of the year. We want to engage with you more because at the end of it, at the end of it all, the reason as to why we wake up in the morning and serve is because we are serving your people. So thank you very much for your time. Make sure to engage with our content. I know Dr. Laibuta had indicated on how they can be able to publicize the work that the Institute is doing. Make a lot of noise. Follow us on social media. Join the WhatsApp group, by the way, if you are yet to join the CIarb WhatsApp group, because that is where we keep all the information abreast. Thank you very much. And I think VC, unless there's something else, we can consider it closed at that point.
Yes, let me just give a parting shot, and thank you for that. Thank you, members, for attending. I hope this session has been enlightening. I can see very good feedback from the members. I just want to leave you with this. Are you in the role of neutrals? Secondly, have you complied? Have you paid your subscriptions? That CIarb will help you to propel your practice from local to international. As you have heard, we've had our members from across 5 countries, different continents. So this is a very good platform that you can use to get into the space of international arbitration. So once you have that enrollment certificate with us, and you have your practicing certificate from London, you can apply any other international placements, and I can assure you that you will be received with open arms. I thank you very much, members, and at these early stages of the year, I want to wish you very well in the year and God's blessings, and let's do the work that we do. Thank you very much.
Thank you.